Frequently asked questions about patents. What is a patent? So, a patent is a legal right that's granted by the government of a country uh, to control, where the patent owner gets to control who can make, use, or sell the any invention that falls within the granted claims of the patent. So that's what it is. It's a legal right to control who gets to make, use, or sell products falling within products, or well, it's probably products or methods that are patented. We're talking utility patents here, by the way, and I'm talking about U.S. law primarily, although I mean there are slight variations depending, but this is basically the same idea in most countries. Um, so that's what a patent is. What does it do? So again, that right to control means that you can use your patent rights to exclude competitors so that you're the only one that can offer this unique product that you invented. Or you can use it to give that exclusive right to someone else in exchange for a royalty, and in that way you're using your patent to get passive income. Um, that's called a license, and the passive income is called a royalty. So that's the reason that you can do that, is because that patent gives you the right to control who can make, use, or sell your invention. Um, there's sometimes opportunities where your invention might be useful across a couple different industries, and so you can actually get passive income from licensing your patent to different companies that are not in direct competition. You can also kind of carve it up geographically, where you have, you know, countries have a geographic territory, not countries, companies have a geographic territory where they can, have exclusive rights to your patent technology, your patented technology. So that's what it does and how it makes you money. Um, what can and can't be patented. So, in order to be patentable under US law in 2026, we do have kind of two levels. The one that people know more about is the one that says it needs to be novel, non obvious, and have utility, to have a utility, to get a utility patent. That is true. There's another level, which is before you even get there, it has to be patent eligible. This is what they call it. It has to be patent eligible subject matter. And what that means is it can't be a law of nature, like the genetic sequence, the genetic code for a particular microbe, for example. That is not patent eligible because it's just something that exists in nature. And it can't be an abstract idea. So it can't be, for example, if you have a novel and non-obvious new way to solve a math problem, that might be really awesome and fun and cool and valuable. It's not going to be patentable because it is an abstract idea. So that's what can't be patented. Um, the novel and non-obvious language can throw people off a little bit. Just keep in mind that those terms have um, legal technical definitions. So what you may think it's obvious, that doesn't mean it's obvious legally. So I'm not going to get into the technical definitions here, but just be aware that you might be concerned that it's not novel enough, or it's too obvious. For instance, sometimes people say, well, I'm using off the shelf things, so I don't think I can patent it. That's not true. You can use off the shelf parts to make something that is novel, non obvious, and useful, and therefore patentable. So don't be too sure that it's not patentable. This is where, we do free consultations at this point. So if you're curious, you can, see what, contact us or contact someone else, but just don't give up on it just because you think it might be, too not novel enough or not non-obvious enough, because chances are your definitions of those terms are not as forgiving as the legal definitions. And then what's the process? So I'm going to kind of speed this up here, but a high level, what you should expect, you can do patent research ahead of time, prior art research, not required, but it's a good idea, especially if you're filing a non-provisional utility patent application. So that's, again, not required, but you might plan on doing that. And that's not going to tell you everything that's been patented or is in the literature, because there's 18 months that is not public, so keep that in mind. So the process, you, with or without your patentability research, you file your application with the USPTO. You'll want to file any European or any international applications at the same time. You can use a treaty called the PCT to do that. And then it will take a while, and I'm talking like, well, what probably will happen first, unless you've paid extra to speed up the process, is your application will be published. So that happens 18 months after you file. Once it's published, anything that is disclosed, it blocks others from getting patented, from getting what's disclosed patented. So that can be a really good thing. It will also block you if you don't get it covered in claims. So keep that in mind. But as long as your patent is pending, you can have the right to try to get patent coverage on anything that you've disclosed. I say the right to try because, no guarantees. It'll depend on the prior art. So at this point, your patent application's been published. Then at some point, maybe 2 years after filing, it'll be assigned to an examiner whose job it is to push back and reject your claims on the grounds that they overlap into the prior art in some way. Don't be discouraged by the word reject. That is just the language, and you should expect 2 to 4 office actions. It's a normal part of the process, and what it means is that you've claimed broadly enough that you can hopefully tailor your claims just to the boundaries of the new available territory and get your claims granted. And what that does is it means that you have claimed broadly enough and not left a whole bunch of territory on the table for someone to design around your patent or get something similar patented. If your patent goes through without any pushback at all, it means your claims were super narrow, and that means you probably have a patent that's not worth as much as, hopefully it is for you, but chances are, your patent is not worth as much as you could have had because you claimed too narrowly. Then once your claims are granted, you have an opportunity to file continuation applications, which is a very good idea. Then you pay the issue fee and your patent is granted. Then you have to pay maintenance fees, 3.5 years, 7.5 years, and 11.5 years to get the full 20-year term. So that is the patent process. Those are the most frequently asked questions that we get about patents. It's Catherine Cabela, IP Works Law. Thanks.